Swayam Prabha. Digital India. Educated India.
Register of Patents. Section 67 talks about the Register of Patents. The Register of Patents is a record that is kept at the Patent Office which contains details of all the granted patents. In fact, it contains the details of all the granted patents. It also contains details with regard to amendments of existing patents and even revocation of existing patents. So, we understand the Register of Patents as a record of all the patents that have been granted and the patents that have been in force. So, this is a public record and it is possible for the public to scrutinize this register to understand what is the status of a patent, to understand who are the patentees, if there has been an assignment of a patent, who are the new assignees, if the patent has been revoked, when the patent has been revoked. So, there are a number of details that the register carries, but the register, we understand the register as a public document that is kept with the controller and it is kept at the patent office. An analogy would be the register of companies under the Companies Act, where the details about all the companies incorporated under the Companies Act are kept by the registrar of companies. Now, if you see the details that are entered into the register, the section 67 once tells us that the register, there shall be kept at the patent office a register of patents. So, this we understand this as a public record, and now the register or the details of the register can also be searched online. The patent office has a website where some of the details in the register can be searched on the patent office website. Now, details such as name and address of the grantees of the patents, the patent holders, their name and address would be mentioned in the register. Notification of assignments and transmission of patents, licenses, etc., and revocation of patents. So, anything that has happened with regard to a granted patent, whether there has been an assignment or a transmission or a license or amendments, revocation, anything that affects the life or the rights conferred under a patent will have to be recorded in the Register of Patents. Particulars of such matters affecting the validity or proprietorship of the patents as may be prescribed. Now, if a validity challenge is made on a patent in an infringement suit and the patentee successfully succeeds in declaring that the patent is valid, there is a provision that a certificate of validity can be issued under the Act. Now, all these things would be entered in the register. Now, the register would not contain certain things. For instance, 67(2) tells us that no notice of any trust, whether express, implied or constructive, shall be entered in the register, and the controller shall not be affected by any such notice. Notice of trust, whether it is implied or constructive, will not be entered into the register. 3. Subject to superintendence and directions of the central government, the register shall be kept under the control and management of the controller. So, the controller is the one under whose custody the register is kept. 4. Notwithstanding anything contained in subsection 1, it shall be lawful for the controller to keep the register of patents or any part thereof in computer floppies, diskettes or any electronic form subject to such safeguard as may be prescribed. As I mentioned, if parts of the register is now available online, it is largely due to this provision where it allows the register to be kept in an electronic form. 5. Notwithstanding anything contained in the Indian Evidence Act 1872, a copy of or extract of the Register of Patents certified to be true copy by the hand of the controller or an officer duly authorized by the controller in all legal proceedings shall be admissible as evidence. Now, if you need to produce any detail with regard to a patent before a court of law, the accepted mode or the admissible mode of evidence is to get a certified copy of the register that is certified by the controller or any officer who the controller has authorized to be a true copy that will be adduced as evidence. Now, in practice, a printout taken from a patent office website will be admissible as evidence. The Information Technology Act allows copies which are displayed on the website to be taken as matters on evidence. But if there is any dispute with regard to rights of a patentee, and if that issue is before a court of law, under the Evidence Act, an extract, a certified copy of the register will be admissible as evidence. Rather than just taking a photocopy of the register, you would insist on a certified copy that is certified by the controller to be a true copy, and that can be admitted as an evidence, in the sense that that will be taken as a true state of affairs by the court in a proceeding, in any legal proceeding. 6. In the event the register is kept wholly or partly in floppy, computer floppies, diskettes, or in other electronic form, reference to this act to any entry in the register shall be deemed to include the electronic form as well, and reference to this act or particulars registered or entered in the register shall be deemed to include references of keeping it in various electronic form. It just means that any copy that is kept in the electronic form shall be treated as a copy on which which is actually kept in the original form. So, the electronic form can be relied as another alternative form. Reference to this act to the rectification of register are to be read as including references to the rectification of record of particulars kept in the computer floppies as well. So, any reference to rectification of register would also mean rectifying the records kept in electronic form. So, this tells us 67 tells us about there being a register of patents, and the register of patents being a public record where the records and details of every granted patent, the names and addresses of the patent holders, the assignments, the transmissions, the licenses, the revocations, the amendment, a record of everything that happens to a patent is kept. And in fact, you would know that whenever a patent is amended, there are provisions of the Patents Act where the controller is directed to carry out a change in the register. When a patent is revoked, there is a direction that is passed, say, by the Intellectual Property Appellate Board to carry the change in the register. So, you will find that regardless of what change happens to a patent in a particular case, that change needs to be carried out in the register, because the register is the public record where people can search and understand the status of a granted patent. So, we understand the register as a public record that is kept. So, even if you amend the name of a patent holder, there is an assignment and a new patent holder comes into the picture. It is sufficient that you do it, filing the appropriate form, paying the appropriate fee, and carrying the change. But the patent controller will have to also amend the register to reflect that change. Similarly, for amendments, if you have to amend your patent, you can file an amendment, a form, say a form 58 or 59, you can file the amendment, get the amendment done, but it is the responsibility of the controller to publish it and correct the register. So, likewise, for everything that is being done in an individual case pertaining to a particular patent, it becomes the responsibility of the controller to carry out that change in the register, because the register is a public record which comprises of all the details that we saw in section 67 to be kept in either in the register itself in its hard form or in the electronic form. And we saw from the provisions of section 67 that the register or the parts of the register could also be kept in the electronic form. Computer floppies, diskettes don't make sense today. Today, when we talk about, largely we are talking about things being kept in the electronic form, that is what could be reflected as a website database or as a database that is kept at the patent office. The rules with regard to the register, Rule 88 tells us that upon the grant of the patent, the controller shall enter in the register of patent at each appropriate office the name, address, nationality of the grantee as a patentee, the title of the invention, the date of the patent, the date of grant, together with the address of service of the patentee. Now, these are the entries that figure in the register. So, if you ask for a certified copy of an entry in a register pertaining to a particular patent. Now, these are the things that you are going to get: the name, address, nationality, date of patent, date of grant, and the address of service. Address of service in most cases would be the service, the address of the patent agent who is on record. 2. The controller shall also enter in the register the patent particulars regarding proceedings under the Act before the controller or appellate board or courts in respect of every patent. We have seen that in section 58 there is the power granted to the appellate board or the high court to carry out amendment to specifications in a proceeding pending before them. So, when the amendment is done, the appellate board or the high court shall transmit a copy of such amendment and to the controller, and the controller on receiving the amendment shall cause an entry thereof and reference thereto to be made in the register. So, we find that in various provisions under the Act, when a change is carried out, the controller has to be informed about it and the controller will have to accordingly correct the records. So, this gives us the provision under which that is done. 3. Where the register of patents or any part thereof is in computer floppies, diskettes or any other electronic form, it shall be maintained or accessed only by a person who is duly authorized by the controller, and no entry or alteration or rectification of any entry of said register shall be made by any person who is not so authorized. So, this talks about electronic form maintained by the patent office. A part of it may be available by way of a website, that is the interface that is allowed in a searchable format, but access and the authority to carry rectifications is only to the controller or a person whom he authorizes. 68. Section 68 talks about assignments, and it states that assignments etc. not to be valid unless in writing and duly executed. Now, whenever an assignment is done, the assignment, there are certain requirements as to how a patent can be assigned. 68 tells us that an assignment of a patent or a share in a patent, which means you can assign a whole patent or you can also assign a share in a patent. A mortgage, license or the creation of any other interest in a patent shall not be valid unless the same were in writing. So, the first requirement for any assignment to be recognized under the Patents Act is that it has to be in writing, and the agreement between parties concerned is reduced in a form of a document embodying all the terms and conditions governing the rights and obligations and duly executed. Now, duly executed can be understood as something that is signed and that complies with the other requirements for any document encompassing rights to be executed. If it requires stamp duty to be paid, we understand it as something that has to be done in that way. If it is an execution that is done by a person residing outside India, then we have requirements on apostille, getting it certified by the consulate, the Indian consulate. There are other ways in which Indians who are residing outside India can get documents executed. So, it implies all those requirements has to be followed, but the minimum is that it has to be in writing and it has to be duly executed. Duly executed, we understand that following the formalities stipulated for similar assignments under the law. 69. Registration of assignments, transmissions, etc. Now, there is a provision where assignments have to be registered under the law. 69(1) tells us that where any person becomes entitled by assignment, transmission or operation of law to a patent or to a share of patent. Now, let us look at these three things. Assignment is understood as something that happens by voluntarily between two people. Transmission is something which happens, it need not happen voluntarily, but transmission can happen when a right gets vested on another entity. By operation of law, say by bankruptcy proceedings, or a person is declared insolvent and his creditors take over his property and patents become a part of that, then we say that the patent has changed hands by operation of law. So, any person who entitled to a patent by assignment, by transmission or by operation of law to a patent or to a share in a patent, or becomes entitled as a mortgage, license, or otherwise to an interest in a patent. Now, why do we have this distinction? We also saw a similar distinction in the earlier section 68. There is a assignment, transmission, or operation of law of a patent or a share in a patent. That's one part. The second part is becomes entitled to a mortgage, license, or otherwise to any other interest in a patent. So, these two things should be understood as interest in a patent would mean we should understand interest or anything like an interest when we say any other interest in a patent, which means mortgage is an interest in a patent or a license is an interest in a patent. So, an interest is understood as a limited right. So, if you have a mortgage, then the mortgage can be redeemed and you can put an end to the mortgage. If there is a license, the license can be put an end to it. So, as long as the mortgage continues or the license continues, you have a limited right to the patent. When the transaction is over, the rights vest back to the person who gave it to you in the first place. But when we talk about an assignment, the assignment is a full-fledged transfer of rights. Assignment, transmission, operation of law of a patent or a share in a patent, in those when we talk about the first part of 69(1), we are referring to an absolute transfer of rights in a patent from entity A to B. We are not talking about a limited transfer. We are not talking about a license to use it for few years, license to use it in a particular territory. We are talking about an absolute transfer. Assignment is an absolute transfer. Operation of law is an absolute transfer. So, by the first part talks about an absolute transfer where the person who is entitled to a right gets complete control over his part of his right, maybe the entire patent or maybe a share of a patent, but we are talking about, to put matters in perspective, we are talking about the rights of co-owners or owners in this part. In the next part, which begins with the words becomes entitled as a mortgagee, licensee, or otherwise to any other interest, we are talking about a limited right to use the patent or to have a license in a patent, which means a mortgagee, licensee, or a person who holds an interest will not have absolute control over the patent. He may not be able to sell the patent, he may not be able to assign it further. There are limitations. So, the interest is understood as something which is limited, and when we say a right in a patent or in a share in a patent, we understand that as a whole right which covers right to do everything with regard to the patent. So, we understand these two parts of 69(1) as either an absolute right or a conditional or a limited right. So, it covers both the scenarios. He shall apply in writing in the prescribed manner. The prescribed manner is Form 16, you see the cross reference there, to the controller for a registration of his title or as the case may be of notice of his interest in the register. So, if he is entitled to a right, he has to apply using this form to register his title. If he has become an absolute owner, then his name has to figure in the records. Or if he is only entitled to an interest, then the notice of his interest will be entered into the register. If he is a licensee, then his name will figure as the licensee. If he is a mortgagee, his name will figure as the mortgagee. His name will not be replaced for the right of the patent holder. He will not be shown as the proprietor. That happens only when he is entitled to the title or he becomes an owner or a co-owner. Only in such cases, that is what I mentioned as the first part. Assignment, transmission, operation of law will vest full rights in the person who is entitled to the right, whereas mortgage, license, or any other interest will only vest a partial right. So, if it is a partial vesting, then there will be a notice of his interest. If it is a full vesting of the right, then the title itself, the registration of the patent will be in that name, in that person's name or in the joint name with co-owners, owners if there are any. 2. Without prejudice to the provisions of subsection 1, an application for the registration of a title of any person becoming entitled by assignment to a patent or a share in a patent or becoming entitled by virtue of mortgage, license or other instrument to any interest in a patent. So, you can see the pattern here. First they talk about title. By assignment, if somebody is entitled to have absolute control in a patent or share in a patent. Then they talk about an interest in a patent, which is by way of mortgage, license or any other instrument which conveys the interest in a patent may be made in a prescribed manner by the assigner, mortgager, licensor or other party as to that instrument as the case may be. So, this provision tells us that the application for registration of the title should be done in the prescribed manner by the assigner or the mortgager or the licensee as the case may be. 3. Where an application is made under this section for the registration of a title of any person, the controller shall, upon proof of title to his satisfaction, A. where the person is entitled to a patent or a share in a patent, register him as the proprietor or co-proprietor and enter the register in the register particulars of the instruments by which he derives title. B. Where that person is entitled to any other interest in a patent, enter in the register notice of his interest with particulars to that instrument, creating it, which means the controller just takes record of the instruments and carries out changes in the register, provided that if there is any dispute between parties, whether the assignment, mortgage, license, transmission, operation of law or any other such transaction has validly vested in such person a title to the patent or any share in a patent, the controller may refuse to take action under clause A as the case may be under clause B until the rights of the parties have been determined by a competent court. So, if there are disputes between owners or if there are disputes between people who hold interests, the controller is not the person who is going to settle those disputes. The controller has some powers with regard to co-owners, we saw that in section 20, but in this case if there is any dispute on an assignment, mortgage, license, transmission, operation of law, then the controller will want the parties to approach the court and get a declaration by way of a civil suit declaring what are the respective rights of the parties. So, the controller would not do anything, he would not take any action unless it is determined by a competent court, and we are referring to the civil courts here. 4. There shall be supplied to the controller in the prescribed manner for being filed in the patent copies of all agreements etc. affecting the title or to any patent or any license thereunder authenticated in the prescribed manner, which merely simply states that you will have to supply copies of the agreements or licenses based on which the change or the person gets entitled to a right. Provided that in the case of a license granted under a patent, the controller shall, if so requested by the patentee or licensee, take steps for securing that the terms of the license are not disclosed to any person except under an order of a court. This is to protect confidentiality in certain agreements. The controller shall take measures of securing the terms of license and to ensuring that they are not disclosed to any other person except by the order of a court. So, this protects confidentiality of agreements that are filed before the controller. 5. Except for purposes of application under subsection 1 or of any application to rectify the register, the document in respect of which no entry has been made in the register under subsection 3 shall not be admitted by the controller or any court as evidence of title of any person to a patent or to a share in a patent unless the controller or the court for reasons to be recorded in writing otherwise directs. Now, unless you carry the change in the register, you will not be considered as a owner of a patent or of a person who is entitled to an interest. This becomes critical when you want to enforce the patent in a court. To file an infringement suit, you either have to be the proprietor of the patent, the patentee, or you have to be an exclusive license. So, if the records do not show you as the owner of the patent or as the owner of an interest or an exclusive licensee, then even if you file an infringement suit saying that you are the owner, but you have not corrected the records in the register of patents, there could be an objection, and if an objection is raised, the court or the controller will not consider the fact that you had an assignment unless that assignment is taken into record and the register has been rectified. So it will not be admitted as evidence. So it is not sufficient that two parties have an assignment, but the assignment has to be communicated, the controller has to have knowledge of it, and the register has to be corrected. Otherwise, the rights that flow to a party will not be given to the party. Now, Rule 90 deals with the registration of title and interest in patents. An application referred to in subsection 1 or subsection 2 of 69 shall be made in Form 16. We saw that. And an application for the entry in the register of patents of any other document purporting to affect the proprietorship of a patent by a person benefiting under the document shall also be made in Form 16. 91 talks about presentation of assignment etc. of a patent to the controller. Every assignment and every other document giving effect to or being evidence of a transfer of a patent or affecting proprietorship thereof or creating an interest as claimed in such application shall, unless the controller otherwise directs, be presented to him together with an application which shall be accompanied by 2 copies of the assignment or other documents certified to be true copies by the applicant or his agent, and the controller may call for such other proof of title or written consent as he may require. So, if you want your name to figure as an assignee, then you have to produce 2 copies of the assignment deed or certified copies or true copies saying that based on this assignment deed, I want my name to be changed or I want my name to be shown as the new assignee. So, the proof of assignment has to be presented to the controller. Now, how does the registration of title or interest happen? After receipt, 92, Rule 92 tells us that after receipt of the application under subsection 1 or 2 of 69, the controller shall register the title of a person entitled or his interest as the case may be by an entry which shall be in the following manner. In pursuance of an application received on the dash proprietor dash assignment registered as dash licensee dash. So, you will change this according to if it's by virtue of a license, you will strike off the other parts, you will say by mortgage, you will not say by virtue of a license dated and made between dash on one part and dash on the other. So, this is the form in which there will be an entry in the register to show that the new assignee has now or the new licensee has now he is now entitled to a right by virtue of the document that is mentioned. Now, there are some other details. Entry of renewal fee. Upon receipt of payment of prescribed renewal fee in respect of a patent, the controller shall enter in the register the fact that the fee has been paid and the date of payment of fee and the certificate of renewal and issue a certificate of renewal. So, every renewal has to be updated every time a patent is renewed, it has to be updated in the register of patents. 94 deals with alteration of address. A patent may request in writing along with fee payable for the alteration of his name, nationality, address or address of service as entered in the register in respect of any patent granted to him. The controller may require such proof of alteration and accordingly alter the detail. If the controller allows a request under sub-rule 1, he shall cause the entry to be in the register to be altered accordingly. 3. If a patentee makes a request in writing along with fee payable for entering an additional address for service in India, and if the controller is satisfied that the request should be allowed, he shall have the additional address of service entered in the register. There are cases where foreign entities file quite a lot of patents in India, and normally they would give the address of service as the address of their patent agents. Now, this provision, Rule 94.3, allows the patentee to have an additional address of service. For instance, if the patentee wants every notice that is being sent to the patent agent also to be sent to the headquarters in India, then this provision, Rule 94.3, allows the patentee to have an additional address of service to be included. And you have to give reasons because the controller has to be satisfied, because then the controller, every time the controller issues some notice of service, he would also mark a copy to that address. Now, this can take care of a real world problem of, in some cases, patent agents not communicating back to the patentee. So that could happen for various reasons. So if you as a patentee needs to have every communication to be sent to you in addition to your patent agent or your service provider, then you would insist on using the provision under 94(3) so that the address, your address, the patentee's address is given as an additional address for service in India. Section 70 deals with power of a registered grantee or proprietor to deal with a patent. Subject to provisions contained under this Act relating to co-ownership of patents and subject to any rights vested in any other person of which notice is entered in the register, the person or persons registered as grantee or proprietor of a patent shall have power to assign, grant licenses under or otherwise deal with a patent and to give effectual receipts for any consideration of any assignment, license or dealing, provided that any equities in respect of a patent may be enforced in a like manner in respect of any other movable property. Now, we had already mentioned in the context of section 68 and 69 that there are absolute rights in a patent. If you are entitled to an absolute right, then your name gets changed as the grantee or the proprietor. You could be a co-grantee or a co-proprietor, but your name gets changed as the grantee or the proprietor. If you are only entitled to a limited right like a license or the mortgage, then the register will only have a notice of your mortgage or your license. It will only have a notice because you don't become the proprietor or the grantee. This section tells us that if your name is entered as a proprietor or a grantee of a patent, then you shall have the power to assign, assignment being an absolute transfer of all the rights, grant licenses, which is a condition or a limited grant of interest in a patent, or otherwise deal with the patent, give effectual receipts for any consideration for assignment or license or dealing. So you are shown as the owner and you have the power to assign, power to grant licenses and give receipts for money that you have received in lieu of a transaction pertaining to your patent. Any equities in respect of a patent may be enforced in like manner in respect of any other movable property. The law with regard to equities are covered by the common law in India, and the patents will, with regard to equities, will move or will be treated just like any other movable property. Rectification of register by the appellate board. We had already seen that the controller has some powers to carry out clerical changes in a register, and he can also carry out certain changes. If the changes are substantial, we had seen that the controller will have to give notice, hear parties and only then carry out the change. So we saw that the controller has the power to carry out clerical changes and also substantive changes. Now what happens if a person is aggrieved, a third party is aggrieved and he wants to correct the register? If a third party is aggrieved by an entry in the register, then the recourse for the third party will be to approach the appellate board. There is no provision to approach the controller. There are limited provisions which we had already seen, but the recourse for any person who is aggrieved, who is not connected with the patent in any way, for that person to get the register rectified, then the only procedure is to approach by way of a petition filed before the appellate board. Now, what are the conditions or what are the grievances for which a person can approach the appellate board? They are mentioned in section 71(1). A, by absence or omission from the register of any entry. For instance, he is entitled to a share in a patent, but his name does not figure in the register. Everything is done, the deal is done, the documents are signed, they are executed, but for some reason it does not figure in the register. So he can approach. He becomes an aggrieved person because there is an absence or an omission from the register of any entry, and this entry being his name, by any entry made in the register without sufficient cause. Let's take another scenario. your name has to figure in the register, but your name does figure in the register. There is also an additional name that figures in the register who has no connection with the patent. He is shown as a co-proprietor along with you. So that person's name continues in the register without sufficient cause, because there is no underlying transaction, there was no assignment to him, neither was he the true or first inventor nor the assignee. So in such a case, his name has appeared without sufficient cause, so there can be a petition taken to rectify and remove his name by any entry wrongly remaining on the register. Now wrongly remaining on the register is like a patent gets revoked and revocation of the patent is not reflected in the register. So you could take a rectification to correct that change, or any error or defect in any entry in the register. So any error or defect that continues in the register, if you request for a certified copy of the register, you find that some error exists which is not correct or true, then you could file a petition to rectify this. Make such order for making variation or deletion of any entry therein as it may think fit. Now this is done, this is within the power of the appellate board to do it. In any proceeding under this section, the appellate board may decide any question that may be necessary or expedient to decide in connection with the rectification of register. Now for instance, we saw that if there is an assignment and if there is a dispute with regard to the assignment, the controller cannot take a call, rather the controller has to direct the parties to go to the competent court. We saw that in an earlier provision. The competent court will decide, which will be a civil court, what the rights of the parties are, and only then the controller will change or correct the document. 71(2) gives the appellate board to decide those issues, may decide any question that may be necessary or expedient to decide in connection with the rectification of register. If the rectification of register, the issue involved in the rectification is whether an assignment is valid or not. Now normally, if there is a dispute with regard to an assignment and if the parties are before the controller, as we saw in the earlier provision, will direct the parties to the competent court. The controller will say, go to the court, settle the issue and come back, I will carry out the change. But the Intellectual Property Appellate Board has the power to look into it, which power is not vested with the controller. 3. Notice of any application to the appellate board under this section shall be given in the prescribed manner to the controller, who shall be entitled to appear and be heard on an application and shall appear if so directed by the board. So a notice of any rectification, because for the simple reason the controller is the person who is in charge of the register. Every notice, every application for rectification of register, though it is done by the appellate board, a notice has to be issued to the controller so that the controller is kept in loop. And the controller can appear, or the appellate board can insist on the controller to appear. The controller need not appear personally in most cases. A representative of the controller can also appear in the IPAB. 4. Any order of the appellate board under this section rectifying the register shall direct that notice of rectification shall be served upon the controller in a manner prescribed, who shall upon receipt of such notice rectify the register accordingly. So any rectification that is carried out, a notice shall be served upon the controller and the controller shall rectify the register. So again we come back to that premise that the controller is in charge of the register. Anything that happens outside the patent office, a change which affects an entry in the register, if it happens outside the patent office, say before the appellate board or the high court, that change needs to be notified to the controller and the controller will rectify the register, because the register is a document that is kept under his control. 72 talks about inspection of the register. Now we had already mentioned that the register is a public record, it is open to scrutiny, people can take copies, certified copies of the register. If it is a true copy signed by the controller, that is admissible as evidence in all legal proceedings. 72(1) subject to provisions contained in this act and rules made thereunder, the register shall all convenient times be open to inspection by the public. This is what we meant as a public record, and certified copies sealed with the seal of the patent office of any entry in the register shall be given to any person requiring them on payment of prescribed fees. So the fact that it's a public record, anybody can take a certified copy. 2. The register shall be prima facie evidence of any matters required or authorized by or under this act to be entered therein. So, this is the prima facie, the first evidence or the evidence that will be admitted. So, if you want to say somebody is a proprietor of a patent, this is the record that is going to prove that, not a printout from the website, not the entry of a name in form 1. All those things do not matter, because form 1 can change, there can be further assignments, website need not be updated. The updated record will be from the certified copy of a register. So, this is another practice tip. If you need to understand the status of a patent, the true status of a patent is only the status that is reflected in the register and not what you find on the patent office website. So, because 72(2) tells us the prima facie evidence in any matter of an entry in the register shall be a copy of that register. 3. If the records or particulars is kept in computer floppies or diskettes or any other electronic form, shall be deemed to be complied if the public is given access to such computer or any other electronic form or printouts of such records of particulars for inspection. This refers to databases that can be searched. So, the record, the register can also be kept in the electronic form, and you would find that on the patent office website you could search for most of these entries and you could find them in their website itself. So, this just allows for the register also to exist in the electronic form. Rule 95 deals with inspection of register under section 72. 95(1) The register of patent shall be open to public inspection during office hours on payment of fees specified in first schedule, and we saw that on payment of fees you can get copies of the register. 2. When the register of patents or any part thereof is in computer floppies, diskettes or any other electronic form, the person authorized by the controller under sub rule 3 of rule 88 shall provide access to computer floppies, diskettes or other electronic forms or printouts of the records, which allows parties to take printouts of the electronic form of the register.